Hey, I'm Paul Rabalais, and in this video, we're going to talk about what is a usufruct. So I'm a Louisiana estate planning lawyer. I help our Louisiana clients get and keep their legal affairs in order. And one of the most asked questions I get over the last almost 3 decades now is, what does it mean to have usufruct? So I'm going to tell you what it means. I really would rather give you the practical effect and then dig a little deeper into usufruct so you'll know more than most other people when someone brings up the term usufruct. All right, so first thing I'm going to do is just give you the definition, which is really kind of worthless, but a usufruct by definition is known as a right of limited duration on the property of another. Enough about the technical stuff. Let's talk about practically when we see it and what it means. So here's when we see it. We see it typically when there's a married couple and they have community property, meaning they acquired some stuff while they were married. Maybe they acquired a home. Maybe they, have some savings. And then the one spouse dies and that, couple or that spouse has things in their name and they didn't have a will. Now the usufruct applies because when a married person with community property dies without a will, our intestate laws, the laws that apply in Louisiana when a Louisiana resident doesn't have a will, state that as to the community property that the couple has, the surviving spouse inherits this usufruct of the deceased spouse's half of the community property, and that usufruct will last until the surviving spouse either dies or remarries, whichever comes first. And then by law, because the first spouse to die didn't have a will, the surviving spouse inherits that usufruct of the deceased spouse's community property, and the deceased spouse's children inherits what's called the naked ownership. So ownership gets divided into usufruct and naked ownership. And, we're in Louisiana where, people from the north need an interpreter when people from Louisiana talk. And when you start throwing out some of these terms and with the Louisiana accent, one of these terms is usufruct. There's an F and a UC in there, and so, that gets kind of crazy. And then you also have this term naked owner. So you throw all that together and you never know what's going to come out somebody's mouth. So anyway, that's the deal there. All right. Now, we don't only see it when somebody doesn't have a will. And my guess is because for many, many decades, so many people died without a will. And by law, this usufruct went to their surviving spouse, that it became kind of common in Louisiana, and it really doesn't exist anywhere else. But because it was so common in Louisiana, I think when lawyers started, writing wills, they wrote wills so that the first spouse to die gave that surviving spouse usufruct. Maybe the usufruct didn't last until death or remarriage. Maybe it lasted for the lifetime of the surviving spouse. Maybe it lasted until death, remarriage, or the surviving spouse kind of living with someone like they're married. So in a will, that term doesn't necessarily have to be the same as when somebody dies without a will, but typically the rights are the same. Although in a will, you can give the usufructuary maybe more or less rights than that surviving spouse would have if the first spouse to die didn't have a will. Okay, so now we're going to start digging a little deeper. So here's where we get into the stuff that, most people who know enough to be dangerous, most kind of ordinary people out there in Louisiana, this is the stuff they don't really know. So now we talk about what are the rights of the usufructuary, that surviving spouse who has usufruct. Now, it doesn't necessarily have to be a surviving spouse that has usufruct, but I like to talk about the practical effect of things, and that's typically what we see. So what are the rights of the usufructuary? Well, it depends on whether the surviving spouse / usufructuary has the usufruct of consumable things or non-consumable things. And so consumable things are defined as things that cannot be used without being expended or consumed or without their substance being changed. A typical consumable item is money. Money in the bank, cash money, checking accounts, savings accounts, CDs. Those are all, that's a consumable item. And so I'll get into the rights of the usufructuary when the usufructuary inherits the usufruct of a consumable item. But now let's also define a non-consumable item, and the rights of a usufructuary are different when the usufructuary inherits a non-consumable item. A non-consumable item may be enjoyed without alteration of their substance, although their substance may be diminished naturally by time. So common examples of a non-consumable item are things like land, a house or houses, shares of stock, vehicles, furniture. Those are typical non-consumable items. Now that we got that straight and we got our definition straight, let's talk about what the rights of the usufructuary are when they inherit a consumable versus a non-consumable. And I'm going to go to our law on that. So let's first talk about what the usufructuary's rights are when they inherit the usufruct of a consumable, like money in the bank or cash. So it says that if the things subject to the usufruct are consumables, the usufructuary becomes owner of them. He may consume, alienate, or encumber them as he sees fit. At the termination of the usufruct, he is bound either to pay to the naked owner the value that the things had at the commencement of the usufruct, or to deliver him things of the same quantity and quality. All right, so practically what does that mean? It means that if husband dies and leaves his wife usufruct of $300,000, she becomes the owner of that $300,000. She doesn't necessarily have to put that into any kind of special account. She becomes the owner of them. Says it right here in the statute. But then it goes on to say at the termination of the usufruct. So when that surviving wife, let's say it's an intestate usufruct, he didn't have a will. When that surviving wife either dies or remarries, whichever comes first, she or her estate owes that $300,000 that she had the usufruct of. She owes that to the naked owners, likely to be his children, or if he had a will, whoever he designated to be the naked owners. So we'll come back in a minute, because the next question, we always get from that surviving wife is, what if it's not there? What if I don't have it? And so let's go ahead and answer it. Well, her estate owes $300,000 to his heirs, his naked owners. And if she doesn't have that cash when she dies, to the extent she has other assets in her estate and her succession that could perhaps need or may need to be sold to cough up the $300,000, that may be something that might be necessary. But that $300,000 debt has to be satisfied first before her heirs can get anything. Okay, so that's the usufructuary's rights when they inherit a consumable item. You look at how much it was when the husband in our situation died. 5 years later, 10 years later, 30 years later, when that usufruct terminates, that's an amount that's owed back to the naked owners. You look back and see how much the usufruct amount was at the time the husband died. Different rule when a usufructuary inherits a non-consumable thing. Mentioned that's like land and houses and stock and vehicles and furniture. If the things subject to the usufruct are non-consumables, the usufructuary has the right to possess them and to derive the utility, profits, and advantages that they may produce under the obligation of preserving their substance. He is bound to use them as a prudent administrator and to deliver them to the naked owner at the termination of the usufruct. Typical non-consumable item, a house, a home. So when dad dies, he had a home. It was worth $200,000 when he died. Wife can live there. She can possess them and derive the utility, profits, and advantages. Okay, so she can live there, but she lives there for another 20 years, and that house grows in value from $200,000 to $400,000. Well, it doesn't really matter what the value of that house was either when he died or when she died. When she dies, the naked owners get the house, regardless of its value. or if it was stock that either appreciated or depreciated after the husband in our circumstance died, the wife, as the usufructuary, is entitled to own the dividends that the stock produce. But when the surviving wife died, those shares then go to the naked owner, or typically naked owners. There's usually more than one, regardless of whether there was any appreciation or depreciation in the stock. So it is different depending upon whether there was a consumable or a non-consumable. Now, it gets a little tricky, not really though, when someone inherits a non-consumable item and then it's sold during the term of the usufruct. So let's take our example. Dad had a house worth $200,000 when he died. That's a non-consumable. Wife lives there and she has a usufruct until she dies or remarries. She hasn't died and she hasn't remarried, but that house gets sold and it sells for $300,000. And so at that point, a non-consumable was converted to a consumable. So now surviving wife, usufructuary, now she has a usufruct of a consumable. She doesn't, the naked owners don't get any of that money from the sale because her usufruct doesn't terminate until she dies or remarries. She didn't do either one of those, but the house was sold. She gets the $300,000. She now has a usufruct of a consumable. She owns that money with the obligation to account to the naked owners at the termination of the usufruct. So it doesn't matter what she does with that $300,000. She might go buy a new house in her name. She might go invest it. She might spend it. But nonetheless, when her usufruct terminates, we go back to the date where that non-consumable was converted to a consumable. And that's the amount that either she, when she remarries, or her estate, when she dies, must settle up with the naked owners and give them that $300,000 that they're entitled to as naked owners. Okay, so I'm going to kind of start to wrap up here, but that should give you some guidance. There's a lot more usufruct law, particularly when you're dealing with a home, for example. Who's responsible for maintenance, repairs. They distinguish between ordinary repairs and extraordinary repairs. So lots of additional law there. We just don't have enough time to get into that. But I will tell you that generally speaking, there's kind of three kind of common thoughts out there about usufruct. The first kind of thing that those people who barely know enough to be dangerous, there's one group of people that when they hear usufruct, they think, kind of justifiably so, that they have the use and they get the fruits of the assets over which they have the usufruct. And that is generally true, but those people really don't typically understand the whole consumable versus non-consumable law that we have. A second group of people think that usufruct is synonymous with ownership. They think, oh, my husband, he just left me everything. Yeah, it might have been usufruct, it might have been ownership, it doesn't really matter, he just left me everything. Well, those people are flat out wrong, because when someone is left ownership, they own it and they can do what they want to with it and they can leave it to whoever they want without any obligation to account to anyone else in the future. But when someone has usufruct, there is clearly an obligation there to account at some point in the future to those naked owners. Now, the naked owners might be the children of the usufructuary, but they may not be. And so, that's particularly when the naked owners are not the children of the usufructuary, it can get a little sticky. And then some people really, really don't like that a usufruct of a consumable creates a debt. Debt is a word that a lot of people don't like. They have worked their entire lifetime to be debt-free, and now their spouse dies and they have a debt to the heirs of their spouse to die. They don't like it. They don't want to have anything to do with it. They want to get rid of it. And so that's when, we have to have some, conversations about that. So there's your kind of wrap up on what is a usufruct, particularly a Louisiana usufruct. It applies, has applied for the last many decades, and I gotta think there's not going to be any kind of significant law change in our state that's going to do away with usufruct. And as long as people get married and they die without a will, usufruct will be around forever. So hope that helps. Now, feel free to down below reply in the comments. I know some of you are going to have some questions about it. There's some questions I read in the comments. I'm like, I'm not touching that one with a 10-foot pole. So, you know, if I think off the top of my head, if somebody writes in, you know, can I sue my stepdaddy because he mismanaged the usufruct? You know, where do I go with that? I'm not even going to attempt to answer that one. But maybe if you type in a comment that says, you know, Paul, can you generally describe what the obligations of a usufructuary are when they inherit the usufruct of a home? I'm not going to answer it in the comments, but I may just generally do another video on that topic. Because really what scares me is if somebody asks me a question and there's not that back and forth dialogue that I always have with people when we try to, you know, solve their problems and give them peace of mind. I don't want somebody to act based on me typing in an answer to what I think the question is. But feel free, your experiences, your comments, your observations, put them in the comments below. Make sure you subscribe. Hit that red subscribe button along with the notification bell so that as you pull up YouTube from time to time, YouTube will keep you notified of my future educational videos. And then, of course, thumbs up. I always like to see the thumbs ups when as people view the videos. Okay. So now you know more than most people about what a usufruct is. So now it's time, whether you live in Louisiana or otherwise, you know, go make sure you get those legal affairs in order. You may be doing a really big favor to your loved ones in the future. I'm Paul Rabalais. Go out and have a great day. Take care.